engaging and stimulating conference. Thanks very much for doing it.
Thank you very much, gentlemen. Thank you, Gabby, and the Law School for your hospitality. And just before we start, I want to say a few more thanks, obviously, to the Minerva Center for Under Extreme Conditions, who initiated and sponsored this event, and also our the Israeli Association of Public Law and Boston College of Law. We work together on this. And of course, they're not listening, but Dr. Michal Bengal and Lily Shaw, who has done all the administrative work organizing this symposium. AMNON organizing this symposium. And of course, my co-convener, Richard Albert, who is doing it with me. So thank you very much. And now Richard will say a few words about the format and about the aim of this event.
Well, welcome everybody. It's a pleasure to have everyone here. It's a pleasure for me to be here. Thank you for your hospitality, Gad and Michal and Lily, the entire group that's helped to support this program. Let me just say a couple of words about our hopes and our expectations for this program. I will say a bit more about the edited volume that we hope to produce out of this conference tomorrow at the closing remarks. But if you have any questions about anything, just catch me during the day, and I'll be happy to give you a few highlights about our plan. Before I say a bit about our hopes and expectations for today, just let me say thank you to my dear friend and co-convener, Yaniv Rodnai. Yaniv is known to all of you. He's known to many people around the world in the field of comparative public law, and it's no exaggeration to say that he's one of the rare people in our field around the world who is both an exceptional scholar and also a great organizer. Sometimes you're one or the other, but very few people are both. And I can say that Yaniv is in fact both, and it's been an honor to work with him not only on this important project but other projects. And so Yaniv, thank you. It's a pleasure to work with you on this important event. So our hopes and expectations for this event, I think I can maybe summarize them in the first is to develop connections and friendships that will maybe spur collaborations in the years ahead. Yaniv and I have worked a lot on different projects, conferences, volumes, and we really enjoy getting to know people and learning. And this connects to the second objective that we have, which is to learn from each other, from different jurisdictions and experiences, to see connections where perhaps we hadn't seen any before in our work across fields and, of course, within the field of comparative public law. The third expectation and hope that we have is that the volume that we produce and the conversations that we have will help to advance our discussions, help to advance our scholarship in comparative public law. And it's no... I was going to say that when we planned this program, it actually emerged, the kernel emerged out of a program that we were at last year, this time last year, at Koç University in Istanbul in June. And of course, we all know what's happened recently, which is, I think, emblematic of the very theme of our discussion for today and tomorrow, constitutionalism under extreme conditions. The institution of constitutionalism is under pressure around the world. Some of it for obvious reasons, but some of it for non-obvious reasons. I don't think there's any part of the world where the institution is not under some kind of pressure. What's interesting, though, I think, is that I would have thought that it's to be expected that constitutionalism would be under pressure. Why? Because constitutionalism sets itself in opposition with at least what we understand to be the majoritarian participatory basis of democracy. And so it's inevitable, I think, that there will be some pressure on constitutionalism because it seeks to constrain the very exercise of democracy by setting rules about bills of rights, about judicial review, about minimum standards of governance that may be pinched down on the popular expectations that citizens have about how they govern themselves. They have to restrain themselves. That's what constitutions do. So I'm very excited from the papers that we've received for this program that we have under discussions of constitutionalism under extreme conditions with respect to financial constraints. And this is Antonius as well is writing about this. We have new and exciting, I think, understanding of constitutionalism under extreme conditions when it comes to new frontiers, dealing with human rights. Of course, the conventional understandings and theories of pressure being brought to bear on constitutionalism when it comes to the notion of emergency. And how do we compare normalcy and emergency? This is, in fact, the first panel that we will discuss. So, just very, very short thoughts about what we have laid out for today and tomorrow. Thank you to all of you for being here, for the time and investment of resources that you've made to be here. And we're looking forward to 2 days of invigorating, productive, and enjoyable conversations.
Thank you very much, Richard. Well, Richard mentioned the coup d'etat, the unsuccessful coup d'etat in Turkey, and I should mention that 2 of our speakers, Atlantic at my time, will only arrive tomorrow because his flight was cancelled. And of course, we have a Turkish participant, Professor Fatih Öztürk, that cannot make it here due to the events in Turkey, and he will hopefully join us tomorrow by Skype. So let me just say a few words about the format, how we're going to conduct this symposium, and then we'll just go ahead. So the basic idea is to get maximum feedback with minimum pressure. That's our aim. And we all know that these are work in progress studies. So the idea that we thought is to have a meaningful discussion without the pressure of presenting something. So what we're going to do, in each panel we're going to feature 2 papers. We will start by the discussant. The discussant will give his remarks, comments, critique, whatever, in about 5 to 10 minutes, more or less. Then Richard or myself will approach the author if he has any things he wants to say, any remarks, anything he wants to comment, and also if he has any proposals for the other participants about things that he is not unaware, if he has any challenges, things he is not sure how to proceed with the paper, so he can guide the other participants about his study. And then we will open the floor for the other participants for the rest of the 45 minutes, but that's what we assign for each paper. Now, what we suggest, if anyone wants to speak during the panel, instead of us writing a queue, simply tell your name like this, and we will know you're on the queue, that you want to speak. The second rule is that if you have something urgent to say, you just want to follow up an issue that just came up, so just raise your hands, and we will approach you to intervene. That way you can override the queue. I think this is it. Can we start?
I think that's it.
Thank you very much, everyone, and let's have a successful event.
And we're right on time. I did want to ask one question before we begin. In the age of the internet, the digital era, it's now possible to broadcast this, our conversations live, and the Minerva Center has a Facebook page, and we would like, if there are no objections, to broadcast this on our Facebook page. So if anyone has any reservations about that with regard to the discussion that we have around your paper, just flag me right now, and then we'll make sure not to broadcast the particular segment that you're involved with on the Facebook page. This is just something that's come up right now, so apologies for not giving you more notice about this, but if anyone is uncomfortable, Guru or MING-SUNG, let us know. No pressure at all, and we will just not broadcast that particular panel on the Facebook page. But assuming everyone is okay with that, let's begin with the first panel. The first panel features 2 papers, one by MING-SUNG Kuo and the other by Guru. MING-SUNG Kuo from University of Warwick and Guru from UCL, University College London. The first discussant will be Ellie SALZBERGER, discussing MING-SUNG Kuo's paper with about 5 to 10 minutes, followed by MING-SUNG Kuo. If you have any questions, any requests for clarification, but we would like to privilege discussion on the paper to give you feedback as much as possible for the paper. And then we'll have YAIR SAGY, the discussant for Guru's paper. So with that, thanks in advance to the paper authors and the discussants. Ellie?
Yep, I have some slides.
But you're sitting under the under the screen, so if you can just for this. Sorry for the inconvenience. in this.
Well, you know what? While we do
High-tech
that,
age.
let's go with Guru's paper while this process is figured out, because I don't know if the slides are connected to the internet. But we'll do that while we start. Should we do that with the other paper?
Yeah.
Should we do that?
Yeah, we can do that.
So YAIR, please, Guru's paper.
Thank you. I was asked to be very brief. I enjoyed reading the paper. So, what can be done with the exceptional council rule? How to integrate exceptional measures into the fabric of normal law? This poignant question is the paper of Professor GURUPARAN. The paper draws on Sri Lanka experience, but also on that of India of the past century. The two countries dealt with prolonged periods of internal conflict. The paper details the manner in which dominant groups existing polities relied on exceptional emergency measures used to suppress separatist tendencies of minority groups within the two countries. Let's focus on Sri Lanka, which occupies the bulk of the paper. It's seen from the vantage point of the hegemonic groups, the Tamil struggle to form their own identity within the island of Sri Lanka undermines the very elongated reason of being of the independent republic of Sri Lanka. As seen from the perspective of the Sinhalese majority, the Tamils claim for their rights to self-determination could be done by the call for the complete disintegration or annihilation of Sri Lanka. Professor GURUPARAN presents a detailed and fascinating account of the course taken by the Sri Lankan government as it unleashed emergency measures in order to protect and suppress the government. Outlined in this description are several essentials of emergency regimes that was particularly for essentials of emergency regimes such as the abandonment of executive bodies, the invention of the new, often bizarre legal categories, the limited role of courts to enforce the militarized regime, and so on. The resulting image is, to be sure, not easy to stop. It is not a pretty sight. It is an image that does not sit well with our perception of liberal democratic legal order. Herein surely lies the reason for pretty little exception. Therein, however, lies the rub. For the dynamic of emergency regime, as described in the paper, is of a sprawling, amoeba-like, even omnivorous regimes. Professor GURUPARAN rightfully and insightfully turns to Schiller, Agape, and even quote, with a seminal work highlighted the fundamental role the state of exception played in defining ultimate sovereignty in the given polity, setting the boundary between those who are regarded as friends and those who are seen as foes. This is essentially Schmidt's contribution, of course. Agape also underscored state of American exceptions tendency to permeate, to underlie the polity's entire legal universe, that is, to underlie its so-called normal and abnormal law. The Schmidt-Agape approach is critical to the core. Seen through their prism, liberal democratic fundamentals, principle of the rule of law, judicial review of the government, and above all, the division between emergency and regular law, lose much of their credence and potency. As I read the paper, which casts Sri Lankan legal system in the Schmidt-Agape perspective, Constantine Cavafy's classic poem, Waiting for the Barbarians, came to my mind. Cavafy famously asked in the poem, why isn't anything happening in the Senate? Why do senators sit there without legislating? And the answer given in the poem is the following: because the barbarians are coming to play. What laws can senators make now? Once the barbarians are here, then do the legislator. Under Schmidt and Agamben, our legal system is always cast in the shadow of the barbarians in the book. Indeed, Schmidt and Agamben challenged any attempt to describe the normal law in the books, the normal law in action of any legal system as distinct from abnormal law. Professor GURUPARAN was naturally faced with this challenge. While he very nicely handled the difficulties, analysis doesn't create a sense of ambivalence with regard to the tenability of the familiar legal precepts, such as the rule of law, in the reality of constant amendments. Still not quite At times it seems to run with the hare while hunting the hounds. Thus, at one point, he too seems to ask how reasonable it is to describe systemic exceptions as exceptions. At the same time, Professor GURUPARAN is not willing to let go of the fundamentals of legality. He appears to believe that the rule of law and judicial review, if genuinely upheld, may still depress personal and individual liberty. Yet, to repeat, this belief seems to fly in the face of his analysis by the bench. Next, the parallels between Sri Lanka and Israel are absolutely striking. To begin with, legally, Israel is in an open and has always been in a state of emergency. Consequently, today, a formidable array of measures is still at the disposal of the executive, and such measures are certainly no place to hide. Additionally, Israel held the West Bank for half a century under military occupation. Since no end is in sight, and at least in this case, it is plain that the temporary has long ago turned into a permanent economy. One final example of the parallels between Sri Lanka and Israel. Similarly to the Sri Lankan Official Language Act, Israel law of return has been proclaimed by our own Barak, with us today, has been proclaimed by our own Barak as the most important piece of Israeli legislation, even though, just like in Sri Lanka, it is not part of the Israeli so-called constitution. This is a testament to the fact that both countries are faced with deep internal frictions, which are, in both cases, the legacy of the British colonial rule. It is certainly tempting and deceptive to trace the origins of the ubiquity of the exception in Sri Lanka and Israel to their British colonial legacy. Indeed, perpetual states of emergency may take unique as well as generic forms under colonial and post-colonialism. Yet, following these laws, the perpetual states of emergency are endemic even to normal sovereign states. Even if, unlike the Sri Lanka and Israel realities, they are not overtly present, they always lurk in the background. Thus, in light of the dramatic events of the past weekend, I believe Professor GURUPARAN's paper presents an interesting contribution to the analysis of the global, acute, and yet ever-present phenomenon. Thank you.
Thank you, Yair. Guru, do you have any thoughts in response? Do you want to ask for clarification? Do you want to direct the attention of the entire group to certain parts of the paper where you would like specific feedback and assistance?
Right. Thank you so much for this comment. Briefly on your comment that about your comment that there is ambivalence as to whether after all the analysis and assessment in the paper, that I go back to the rule of law and good governance frameworks and federal constitutionalism as an answer to this problem. I do think, and I apologize for the sort of rudimentary nature of the paper. It's still very much the early stages of work in progress, but I do argue in the paper that the simple mantra of liberal peace, of rule of law and good governance, do not respond to the very complex situations that we face in the international context. And that I make the argument that there is a much more fundamental, that the rule of law and good governance questions only arise after sort of the state the nature of the state question is settled, what I call the nature of the state question is settled, wherein then rule of law and good governance questions are appropriate sort of instruments of liberal constitutionalism to see how you can keep military power in check. But where there is a fundamental question with regard to the character and nature of the state, in terms of its composition, very fundamental questions about the locus of constituent power, so on and so forth, that the liberal sort of peace prescription that if you reform your markets, if you have separation of powers, if you have rule of law, that things in the plurinational context, in deeply divided contexts, might improve, I think, are wrong. So I do think that in the paper that I try to push back on that sort of liberal constitutionalist assumptions about how to respond to conflict in plurinational contexts. In terms of the paper, I think there are 2 points that I want to draw attention to and possibly feedback, because these are possibly moves that I myself am thinking about. Is Schmidt's identity of the sovereign being as something that emerges out of the state of exception. And in the plurinational context, I argue that the identity of the sovereign isn't particularly a particular institution within the state, but also probably also to a particular polity within the, and I argue that the dominant nation within the state might actually hold the reins of the sovereign who identifies the state of exception and then perpetuates the state of exception to further reify the friend-enemy distinction. So I would be grateful for comments. The other is the nexus that I draw between the desire for centralization of powers, particularly in plurinational context, but also particularly in South Asia, where the idea of state reform around evolution of power is a very difficult idea, possibly India being a reluctant exception, I would call it. But as to whether, and the connection that I draw between centralization mounted on the justification of necessity, and how that relates to constitutional design in deeply divided societies. So those are 2 moves in the paper that I make that I would be interested in hearing comments about. I just wanted to clarify my use of Schmidt and Agamben here. I mean, I'm obviously not normatively as a value proposition agreeable to Schmidt at all, but I think the friend-enemy distinction he draws, despite its sort of, shall we say, crude binary nature, does make sense in the context. I've tried to be nuanced about how I draw from Schmidt on this, but I would also, I know that this may be controversial. I'll be very happy to hear any comments on that particular way of drawing. I know that there's a lot more sourcing, referencing that I need to do in the paper, so any questions about some of the arguments that I make is probably need a lot more backing up in terms of sources. So there are any sort of clarifications that I require in that sense, I'll be happy. But this is sort of, I've thought about the paper quite a bit, but it was written within a week. it's still in sort of preliminary developing stages, but I'm very happy.
State of exception.
I'm sorry.
State of exception.
Yes.
The paper itself is a state of exception. Let me remind everyone that if you would like to get on the queue, just tilt your nameplate, and then we will call on you for comments or questions for this particular paper. Let me. You take us through in your paper an important starting then Guru, where plurinational states. But you stop short of giving us a prescription for the diagnosis. And I understand why you do that. One, it took a lot of ground to cover the actual diagnosis, paper in and of itself. The second reason, though, is that it's a difficult question, maybe more difficult than actually identifying the diagnosis, although I would say the diagnosis itself is important because it's a challenge to the very foundations of constitutionalism. the foundations of constitutionalism are in fact liberal. And here you raise, I think, a significant challenge to those foundations. So, recognizing that, granting that, I do want to at least press you to start to think about what some prescriptions might be. And in thinking about the prescriptions, I want to ask whether the prescriptions would apply across jurisdictions. So you focus on two countries that they're not the same, but they're similar, right? Sri Lanka, India. I wonder if the prescriptions that you might give would be the same for other plurinational states currently in armed conflict or leaving armed conflict, post-conflict states or current conflict states. So you might think of countries in Latin America, for example, with the same prescriptions apply. So I understand why you don't go there quite yet, but I think it'd be interesting to think about. AMNON, I think, has a thought.
I think it's actually connects with the comments of Richard. I want to first of all continue where Richard just ended by asking, to what extent can we generalize from this fascinating analysis to something larger than that? Now, clearly, we don't want to. I mean, we're a group of constitutional or comparative constitutional, so we know that to say something global is, by definition, something that we should be wary of because things are nuanced. But to the extent that you talk about post-colonial societies, so it's not just about the conflict, or is it? That's the question. Is it the presence of a conflict, an armed conflict, or is it this post-colonial legacy that puts something in the wheels of liberal constitutionalism that makes it just difficult? Because on the one hand, as Richard was saying, there's something liberal in the idea of constitution per se, in the democracy, but on the other hand, you have your colonial legacy and the mess the colonies have left that you have to deal with, which require liberal, to an extent, non-liberal measures, sometimes embedded in the constitution making itself. So that's question number one. To what extent can we draw something larger than that, and is it related to post-colonialism? The second question I wanna raise has to do with the unique constitutional moment, so to speak, about the constitutional making. So what I read you, and I think it's fascinating, that within a constitution, within the moment of, or the period in which constitutions are made, there must be, or it is expected that friend-enemy distinction, or us-them, let us just call it an us-them distinction, because when you define your sovereign, you define yourself vis-a-vis the other. So if you're Canadian, so it's us vis-a-vis the United States, because we like them, but we don't want to be like them, for sure. Because you tell a Canadian that you're like a U.S., that's an insult, clearly an insult. Generally speaking, we have to be. I'm sorry?
But not the other way around.
Well, if you tell the United States that they're like Canadians, they will just say, what are you talking about? I mean, Canada, what? I mean, where's Canada? Remind us. That's center periphery, but that's a different. So the us-them is interesting here, especially when, and there's another point, in divided societies. So who is us and who is them, and the moment that you make the us, but you have the them in the us, and then what happens with that? Maybe I'll stop here.
Giannis?
Thank you. I found the paper very interesting. What you ask? Well, first, I think that you make an interesting introductory point in the context of the conference, which is that we have to go beyond the acceptance of liberal attitudes and beyond taking for granted that the formal constitution and the judiciary will be able to sustain the rule of law. So my question is, for purposes of communication as well, in the context of Sri Lanka, how should we conceptualize the problem at its root. I mean, is it a case of a nation state where people fight on a concept of ethnic constitutionalism, saying, placing questions of inclusion and exclusion of identity? Should we think in terms of inclusion, exclusion, identity, and somehow a kind of an effort to define the state as my nation state as opposed to the others? This is my question. Thank you.
Let me pause here, Guru, to see if you have any thoughts in response, but not necessarily full responses and give answers, but if you need some clarification, if you want some follow-up.
I'll start with the last one, if I may, the last question. Yes, so I do argue that rule of law, independence of judiciary, these versions of liberal constitution are insufficient to answer the problems that I raised. Are characteristic of these divided societies, particularly the socially protected ones that I've seen not conflict. So take Sri Lanka, for example, the best sort of period wherein we had an independent judiciary, so to speak, was between the 1950s and the 1970s, before the advent of the first African constitution that threw away the idea of judicial review. But this was also the period where the judiciary allowed the official language act to stand scrutiny of Section 29 of the Sri Lankan Constitution, of the Ceylonese Constitution at that time, which provided that there can be no legislation that discriminates against a particular community. And also this was the period when the legislation sought to ease out certain sections of the Tamil community, the disenfranchisement that was passed, and the judiciary again found procedural, technical sort of tools in its armory to let it pass. There's been there's a lot of literature on the subject, not a lot, but significant literature on the subject of how judiciaries in deeply divided societies also tend to reflect the dominant sort of community view, a holistic understanding of society. For example, Stephen Tyrick is exemplary, but there's also I think some scholars working on Northern Ireland and Scotland have also commented on what would otherwise consider to be an independent judiciary, liberal constitutional standards, being averse to prove natural questions and being insensitive to prove natural questions. So it's not just Sri Lanka or India. I mean, I give you the example from India, for example, with the Indian judiciary, which is highly regarded and celebrated in the West as sort of an activist judiciary that has promoted human rights. On the question of, for example, writ of habeas corpus applications of Kashmir, has laid out with very regressive judgments on their review judgments of the Armed Forces Special Powers Act as it applies to the northeast of India and Kashmir, have again handed down very regressive applications that have, despite their blatant sort of unconstitutionality with what would be the basic tenets of the Indian Constitution around the fundamental rights chapter, has been allowed to remain in the legal route, so to speak. So hence my so it is. I don't think it builds on scholarship that is already there about these basic liberal constitutional assumptions not responding to the very specific problems that plurinational societies face. And so then what are the sort of descriptions? And my sort of, this is the larger the larger PhD is connected but not so connected as well. The larger PhD is looking at the normative dimension of the internal aspect of self-determination in public international law. That's my in public international law and drawing from comparative constitutional law. But the argument there is that the root of the problem is the nation state, so to speak. That when the colonial powers sort of helped or took the lead in drafting constitutional design for the colonies that they were leading, they very much assumed more or less that, particularly the British, the Westminster parliamentary style sort of universal franchise, one vote for one person, largely unitary state, with the exception possibly of India, might if the questions might fit into societies that had a very different background and understanding compared to one the British experience was. In fact, there are colleagues of mine who have argued that if they are drawn properly from their unionist constitutional sort of understandings that they had with Scotland and all of that, that it would have been better for some of the Asian societies. There are some scholars like KUMARAVADIVEL who are now drawing from, looking into the legal history, the legal constitutional history of how particularly UK, Britain as a colonial power was involved in constitution making exercises in the phase giving independence. So I think that we need, the key shift that we need to make in thinking about some of the solutions is from a nation-state idea, in the fixation with the nation-state, even despite it being an important idea in the colonies, towards a more sort of plurinational context. And Kimlicka talks about some of the difficulties. Unlike, for example, in the West, in Asia, you have this is very much deeply still a security question. It's a securitized question. There is a deep, there is a drawing of link between a united state and a unitary state. So territorial integrity, countries remaining together in one piece is directly linked with the constitution, with the character of the state being unitary in nature, with the centralization of powers. And so these have to be unraveled for us to be able to move towards a plurinational, a normatively plurinational, I mean, sociologically plurinational. We know that they are multiple, they are diverse, towards a constitution that reflects it. And in that, talking about emergencies and the use of national security laws in particular, I think one of the biggest debates, for example, in constitutional reform in Sri Lanka, which is currently, again, there is one more attempt that is underway, but also in India in a number of contexts, it's about who holds power over subjects like police, land, and largely the question of security. So should police powers be a devolved subject? Who shall have the right to invoke state of exceptions of emergencies? So those are very much related questions in these plurinational contexts. And so there is a link between the locus, who identifies the state of exception, who sort of promulgates emergencies, and about whether that can be diversified in a context where you have a plural understanding of sovereignty, where you have a pluralistic notion of sovereignty, where you agree that sovereignty can have different locuses of holders. And if that is the case, then I think that is the best assurance against what I find to be a very dangerous mix of tendency to centralize powers and to use emergencies to create design of small states, the use of emergency powers towards design of states. So I think a normative, politically a normative move towards a plurinational sort of state, plus constitutional design that doesn't centralize it, that is not focused on centralizing powers in the center, might be ways of looking at how to do it.
Thank you. So we have a number of questions. First, let me just point your attention to the very lovely booklet that you have. All of the bios are in there, so I won't. That's why we're not introducing people. We're referring you to the bios. Pedro, question.
Mark paper, and I would like to draw attention to what I consider to be an overarching issue within several papers, and a topic that is intertwined. And without getting ahead of presentations, I cannot mention that this is present with MING-SUNG paper. So when you say on page page 7 of your paper that the normal law then was nullified by the political despite not being in a legal status of exception or emergency. And this is, again, in some way on page 13 before section 3 where you say, but you describe how even after the declaration of emergency was set to lapse in August 2011, the state of emergency practically continued. So is this an indication of how, even though there is no formal legal declaration of emergency, facts tell us otherwise? Here we engage in an empirical assessment and an interpretation of what is going on in the country as a sort of contradiction with the absence of a formal legal declaration of a state of emergency. So I think I saw this in several papers, and maybe this is a part which, throwing upon previous comments, where we can throw in to what's a common issue within discussions about emergencies and constitutionalism, where sometimes facts are disjointed from the legal or the formal legal procedures, and this is where we need to somehow exercise our own criterion. There is or there isn't, which argument we're going to use to establish that there is a state of emergency, even if officials don't say so, and so without getting ahead of, because this will also be brought the following section, following presentation, so I just want to draw attention on this and whether this is the case that you openly say that there's this disjoint or this contradiction between facts and numbers.
Anna?
Yes, when I understand you correctly, you see the main conflict between moral naturalistic societies and emotional, for example, self-determination and the unity of the state. So self-determination is emotion which threatens the unity of the state. I wonder though, and this is, I find the end of the paper actually indeed most interesting, but it's clear that that's really has to arrive first. However, it's clear, or it shows, your analysis shows that state of emergency is an instrument of political power. Those who are in power, those who are in charge, and those who are in majority, because they can declare what is actually a state of emergency, also saying your right to self-determination is actually violating the unity of the state, and that's why it's a threat, and it can be used in order to suppress these movements. I wonder though, is that not a very natural reaction of the state? How can you solve this differently? I mean, if you say that maybe the concept of the state as such is a problem. The concept of the nation state, as you mentioned, is a problem. However, if you, in the currently existing world, you have to say it is still the predominant organizational tool, the nation state, in the state of a pluralistic society, of a democratic society, who says it is the majority vote that you actually stay unified apart and not political survival. So indeed the question would be, how can a state who wants to be, economically unified, politically unified, how can this problem be solved? Like you said, we have to, if I understand you right, we have to reset the powers and the decision motions. We need to include this power. But this needs to be solved still within the constitutional concept. So again, we are at the beginning saying, is this then not really, again, rule of law, good governance, pretty much solved? Or is this, did I not?
The question is clear.
So, MING-SUNG.
Thank you. I think in terms of the those who write my own, two brief observations, which I think the answer to may also give me some feedbacks. And I think I think Kumasi is absolutely correct to point out that there is a gap between the liberal diagnosis and the not so liberal observation of the fundamental question facing constitutionalism, namely the political character of how a political community can sustain in the initial stage. I just wonder whether it's one thing to say that liberal constitutionalism got it wrong in terms of a diagnosis. It's another to further assume that the kind of Schmittian response to the Schmittian question itself is correct. I mean, liberal constitutionalism may get it wrong in diagnosis, but can we recast liberal answers in a political light? Then we may read the constitutional responses in a new light. In this way, we might turn the Schmittian question on its head. And on this point, I just think Kuma may be able to make some clarification in the final draft. Because when you point to the Schmittian scholarship, you focus on this political theology. I absolutely agree. But I just think there's another monograph on the question of the emergency constitution. Dictatorship seems to be left out in this context, and in dictatorship, actually, he classifies emergency or dictatorships into two types: commissarial and sovereign dictatorship. And I can find a clear connection between sovereign dictatorship and the sovereign question he raised in political theology, and apparently this is the line you pursue in your discussion. And I just want to hear you say more about how the other line of dictatorship. If we read, it's also possible to connect his sovereign question in political theology to his idea of commissarial dictatorship. This may tend the Schmittian solution itself, and that's the point. I think it's kind of a follow-up on YAIR's comment. I think it's one thing to say that now some countries have lived in a perpetual state of emergency, but we still can make a further distinction between those countries where the perpetual state of emergency is just kind of background institutional environment, is where the full force of a state of emergency have been brought to the fore, like Sri Lanka or other conflicted situations. Thank you.
Andreas.
Yes, I'd like to formulate two comments, which are also more or less a follow-up of what's been said already. The first is, I think your paper addresses one crucial question, which is whether or not constitutionalism and law as such has the power to bridge cleavages in deeply divided societies. So, and plurinational societies are only one special case of deeply divided societies. So we see different forms of deep cleavages rising in Europe, for instance, currently, where we are approaching deeply divided societies. So has law the power to do this, to bridge these gaps? And well, one can become quite skeptical about that. If there are not political forces which sort of help constitutionalism, help law to bridge these cleavages. So, and that maybe turns a bit to the argument I would like to make in my paper, which is that you need some mediator in situations like this, which helps to do it. So this is the first point. And the second comment is whether or not your theoretical framework is not too Schmittian. And this is important too, because in a post-structuralist perspective, if you look at reality through a special sort of with some special lenses, like Schmittian lenses, you create that reality. So if you describe those conflicts in Sri Lanka and other deeply divided societies with a Schmittian theoretical framework, you sort of create those problems too. So, and that's problematic. And I wonder if you shouldn't look at those problems with the help of other theories of sovereignty, because the Schmittian one is quite problematic, as you argue too. And especially in plurinational societies, I wonder why the term doesn't appear anymore. So, principle of subsidiarity, a principle of divided sovereignty, where you do not have this unitarian national state with us against them, but where different communities can coexist within one political community. So I wonder if you shouldn't add at least some theoretical reflections on divided sovereignty and federalism into that paper, which would help to, well, balance a little bit that theoretical framework problem.
A lot of food for thought. Guru, at that, I'll ask the group to join me in thanking YAIR and Guru for this first session. Thank you. Let me now call on Ellie SALZBERGER, with apologies for skipping you before, because I feared that it would take time, but it took no time at all to put the material on the board.
Thank you very much. I was very, very happy that MING-SUNG paper is the first paper, because it really sets the theoretical framework, and I think it's a wonderful paper, which basically, you want me?
I will.
Okay. Which actually sets the history of liberal democracy from the executive model, which Carl Schmitt, the switch model of the executive, which Carl Schmitt criticized, through the control model in which the legislature, the executive, and the judiciary take part in the switch, to what MING-SUNG suggests constitutional mindset and judiciary decider of the switch. But I want to take this opportunity to set some of this framework and theoretical construction, criticizing some of the things that you said. First is the distinction between normality. I think that your paper and some many other papers relate to two situations: normality on one side and exception, emergency on the other side. I don't think that this is the case. I think that we have a dichotomous line. We have a dichotomous line between normality, and actually philosophically we don't have a normal situation. Every situation is different from a different situation that was before or after. We have an emergency situation and we have an exception. Emergency situation can be legalized and constitutionalized by the rule of law. Of course, when actions are predicted or are non-imminent, they can be addressed in advance by emergency constitution. Only when situations are either unpredictable or imminent, we move to the state of exception in which we didn't think about what should we do in such a situation. Of course, there is a problem that there is a self-interest of politicians, okay, not to deal in advance with emergency in order to switch to the state of exception. So this is one point. The second point relates to the rule of law. Okay? We're talking all the time in the context of the rule of law. And I think here also we have a dichotomy slide. Thick rule of law, full rule of law, which is formally that any rule is made by law, and law is enforceable to everyone, and is equally enforced and so forth. So, but it also has a substantive facet, and I think that many of the distinctions and many of the papers here relate to the deficiencies in the thick rule of law, that basically there is anti-liberal legislation. But anti-liberal legislation is not emergency, and is not exception. It is legislation that is dealt with by the parliament deliberatively. It is legislation that is scrutinized by the courts, and it might end with less liberal results. Okay? So this is something that might affect the thick rule of law, but it doesn't really step outside of the rule of law. Okay? You relate to the Oren-Gross models, and here I think there is a very interesting tension and contribution, because I think that some of these models can be accommodated to the full rule of law. Accommodation, for example. If a legislator, after deliberation, after constitutional review, adopts laws that are less liberal, this is not emergency. This is not certainly not exception. Okay? What the problem is with the extra-legal model, okay, that ex post ratification, and I think also the American model, which is a prerogative power model, which is basically the worst model possible, because you assume that the president has prerogative power, which are even not mentioned in the Constitution. Okay, and the president basically can do whatever. America is now the Schmidtchen problem. So this I will be very brief because I have a lot of points, but everything will be discussed in next. Michal, can you shift the next one? Okay, so I think the main issue here is the gap, the philosophical gap between the ontological and the epistemological dimension of the rule of law, of emergency and the exception. And I think that the post-World War II, the switch from, or the shift from the executive control to the three separation of powers, or the three powers controlling the state of exception, the state of emergency, is easily the epistemological, but not ontological dimension of the rule of law. How do we know the state of emergency? So the philosophical gap is not really cured by the switch from executive control to separation of powers. And now, with the ontological part, how do we know if there is a state of exception or a state of emergency? Then, of course, we have to presuppose whether a situation of exception or emergency is an objective truth outside there, or it's only the perception of preferences. If there is an objective truth, you may use of the Condorcet theory, but you have to really go further up. Because if there is one expert, okay, who has the best chances to know when there is a real state of exception, we should resort to the control model of the post-Second World War. And this is basically the extension of the jury theory. This is the decision-making rule, the optimal decision-making rule, if we assume that there's an ontological truth behind it. If we don't assume that, preferences aggregation is a solution. Of course, preference aggregation is by the procedure of enacting rules, also in emergency, if we have a constitution, emergency constitution.
I think it's that one.
So, the problem of the control part, which he says, is with which you said is better than the executive, but not as good as what you suggested, constitutional mindset of the defense. Okay, solves the if, okay, you assume certain assumptions with regard to the ontological dimension of the state of exception. Okay? The control paradigm actually uses the epistemological dimension, but not the ontological. Okay? And the last point is the solution. Okay? The constitutional mindset dominated by the judiciary. And of course, there are problems because, first of all, the power of this argument has to overcome the proposition that the ontological of the dimension, the gap between the dimensions, the ontological dimension, is not dimension. Secondly, of course, judiciary can be a solution if the judiciary is really independent and qualitative. And of course, if you take politicians into account, who they want to be in the judiciary, we see it now in Turkey. Okay, the first move out of one was to arrest 2,700 judges already in a constellation of a very, very non-independent judiciary. So of course, this, the constitutional mindset in the judiciary as the dominant of the monopoly on the switch depends on the judiciary. The second problem is the slippery slope problem, as we see in Israel. Okay? The judiciary of Israel, like the Indian judiciary, is maybe one of the most judiciary, but situation of the actual substantive legal arrangement shift anti-liberally, the judiciary eventually will also shift. So it will be always, even if it's independent and qualitative, it will be always as a guardian of the political forces. But if the whole picture shifts, the judiciary will shift with the whole picture. So I'm not sure the judiciary is really the answer or the optimal solution to the problem of the control paradigm destination. I will stop here.
Ellie, thank you very much.
Wow. I think.
MING-SUNG, don't feel compelled to respond to everything. Seek clarifications if you want to. Yeah.
No, I don't think I can respond to everything. Because first of all, I like to thank Professor SALZBERGER. I think the ideas I want to express in the paper are in a very cogent way, and at the same time, he has gone beyond what I have thought in the paper, actually taking the many steps forward to a new theoretical frontier. So I think I agree most of the points the foundation of the entire paper, and I appreciate the diagram he presented, which clarified some important issue in the scholarship on constitutional emergency. So I agree. I think I just want to make one clarification here. I think in the first diagram, Professor SALZBERGER pointed out a continuum from normality to emergency and to the exception, actually it's not. It's also predicted by the law itself. So emergency should be discussed within the frame of a law instead of a fact, and it's in the factual end exception in which the law seems to vanish because of the unpredicted situation emerges. And I think here we can see clearly norm and fact be integrated in a unitary framework. I think this would help us to reflect upon the relationship between fact and norm in the situation of emergency. That's also what to present in the paper. So I think in submitting my proposal, I didn't make this distinction. So I used the term of the state of emergency and the state of exception interchangeably. But in writing the paper, I myself try to I thought some clarification should be made between the normative or still law-governed state of emergency and the factual challenge posed by unpredicted and on the events I use the term the state of exception, and if I'm not sure, but how much progress I've made in my draft, but I think the current I regard myself still as a constitutional lawyer, so the task I pose to myself is whether we can respond to the question, the legal question posed by the empirical situation, i.e., the state of emergency. So that's something I want to clarify, but I think Professor SALZBERGER, who did a better job of clarifying this part, and so this may also, I think this continuum also translates to the thinking rule of law, and extra legality. We can see clearly how this works. And I also want to thank Professor SALZBERGER on a particular point. I have to confess, when I tried to bring Constitiotionalism jury theorem to my discussion, I wrote this with the theory because I know SALZBERGER is an expert in public choice theory or economics, which I don't know much about. But I think here he points out one thing I really missed. I didn't think about it when I wrote that part. The precondition for the Constitiotionalism jury theorem to apply, whether there exists a real expert, and I think this seems to be a nice way to resurrect Kashmir's focus on solving when he approached the question of the state of exception. Then I just wanted to say one thing about my judicial solution. I think I want to clarify. Yes, my proposal converged with what I have called control paradigm, which is also within the liberal tradition, emphasizing the judicial role in the state of emergency. But I tried to recharacterize the role played by the court in the situation. It's not really to control, what the judiciary could do, in my view, was to set out the legal, the principles for further political action by political actors concerned, including citizens. That I think that's the real control that, if any, which we can expect of a constitutional order in the face of the challenges posed by constitutional emergency. And I also agree. The judiciary also presupposes some institutional conditions, as the case of the United States and Turkey have made abundantly clear. And I think here I just I think maybe we need to take count of one factor, the temporal difference. I'm not naive about the immediate judicial intervention in the when the state of emergency is declared. I don't think it would be realistic to expect the judges to lift the state of emergency or even say anything about the legality of the state of emergency declared. But later, that's not the only. That's not the end of the story about the constitutional regulation of the state of emergency. So we can expect it takes time for the cases to reach the highest court, the constitutional court or the Supreme Court. When it comes to that, the judiciary itself might have more space to say something. Of course, this I'm not naive that this suggestion would also implicate the criticism of say late justice is no justice at all. But state of emergency, just like the constitutional moment, is a process, not just some kind of instantaneous event. So I think taking this into account, might still be hold cautious hope for the response of constitutionalism to state of emergency.
Thank you, MING-SUNG. Anything else before I do that? Great. Remember, you can turn your name tag upside down, and we'll call on you. MING-SUNG, I guess I want to invite you to reflect on Pedro's question. And there he is. Pedro is putting his name tag up. I took his first comment as directed certainly to Guru's paper, but I think more so to yours. Let me invite Pedro, maybe now. Yes, please.
Thanks. Draw on this again on this set of facts and how we say page 28. We live in a de facto undeclared state. And being undeclared, they turn invisible to the public. And I have to admit, while I was writing my paper, I was thinking about the other way around. That means, and thinking about the Latin American context. Usually the concern that you see in the theory is how a state of emergency is declared without having factual grounds, and this can lead to power grabbing if there is no factual justification for a form of state of emergency, and yet it is declared. It is assumed that the reason is to get more power. Whereas here, and I found this very provocative. And I'm just wondering, and this is a great question because I hope I'm not misreading into this. And in your conclusion, you also say we have at the age of normalization in which an unprepared permanent emergency regime has been formed. And this is an actual assessment. And considering how you claim that this is invisible to the public, and therefore I was wondering if you want to make the prescriptive, so is that the tone of the discussion we want to claim that not declared makes it worse, or it hides the true emergency happening, which would be the other way around. We have an empirical state of emergency, but we do not have a formal one. Again, in contrast with what I was assuming in paper to be the main concern of us, liberal constitution, at least some of the authors. So would this be the case of your paper, that you are more concerned of the undeclared state of emergency insofar as it is hiding the actual emergency, or at least the measures that are being taken, which could only be taken on this emergency?
Maybe a follow-up on that. So there is this debate, just three very brief points. There is this debate between norms and facts, the Habermasian conundrum that we've been debating. And here the question is, how do we perceive the shift between emergency to exception that Eli talked about before? This is something that we've been discussing in the Minerva Center for quite some time. We can see it as a continuum, or we can see it as a break, in fact, not just this continuum. And it's actually different. So you can say that as a matter of fact, when law vanishes, we are in a state of exception. Regardless of what the law says, we are in a state of an exception. So that's, again, to draw on Eli's perspective, that's an ontological, there is no law. But then the question is, what does it mean there is no law? The law in its own terms does not apply, or what do we make of it? Because if you go to Kelsen, then part of what the law is whether you apply it. Kelsen accepts the proposition that a law that isn't applied loses the force of law at a certain point. So then the facts and norms are actually, the interaction between facts and norms is actually way deeper than, okay, we no longer, the law vanishes. The law vanishes because there is no law telling us what to do when we have a cyber attack and all systems crash and now we're on our own. Or the law vanishes because there is a law, but we simply don't abide by it. So these are two types of, so this is number one. With respect to emergencies, there is this point of declaration, non-declaration. This is my second point, declaration, non-declaration. You look at the British model, and in Britain, they moved away from declaration. They moved to the ontological, is there a state of emergency? To the extent that there is a state of emergency, a minister, a certain kind of minister, may exercise force. So maybe in Britain, you trust your government, these are civil servants, you like them, we like, okay, that's fine, that's fine. Or you realize that this business of declaration, which business, is actually not the right kind of work you want it to do. Do we want to litigate it now? Do we want to litigate? What does this switch do from, now I'm talking about emergency. Okay, so maybe this declaration business isn't doing, so if it's non-declared, is it declared or non-declared? And the question is whether it exists or doesn't exist. The emergency regulated by the law. The last point I want to talk about is this notion of judges and the judicial process and litigation. So judges have an advantage, an institutional advantage, but we know that the constitutional litigation has a lot of disadvantages. You mentioned this temporal ex post ex ante business. Now, Oren Gross talks about this. He has an answer in the model. But we know that judges are not necessarily the right kind of experts. I mean, they are experts with respect to human rights, and they can be sensitive to power grabs, and they can force the executive to have evidentiary basis for their action, whether it is declared or not. But I was wondering whether we shouldn't focus more on expert expert is that experts that are not judges. And there are some suggestions that in the emergency business, we should delegalize it and put more input of experts, just because the law in its adversarial form doesn't help us in situations of emergencies. It becomes part of the problem, not necessarily part of the solution. So that, I think that should be discussed as well.
A lot of questions for you, MING-SUNG, so I'll continue if I can. Karin?
So, just another question about this issue of expertise. It's clear that there is a question if there is an expert to considering whether there is an emergency. I think in the fields, different fields of disaster management, the common idea is that it can really relate to it as a purely expertise issue, when really what you asked about is where the emergency is and who can tell us where it is. Maybe it is the people who suffer from it that can tell us where it is. Maybe it's the regular problem-solving actors in society, within the society, that can tell us if there is a situation. Or maybe they are hidden and part of the structural problems of society who can tell us who it is. It's a much more democratized situation when we try to think about who is the expert at emergencies. And that's why I think it makes sense to regularize the openness of the to regulate the openness and the flexibility of a given system to those many voices who can tell us those hidden emergencies, where they are, and where we should look at them, where we should contest them when they are falsely claimed.
Antonia?
Yes, I also know about the role of the judiciary, especially refer to the role in a composite state like EU, state EU, but it's a composite constitution, we can assume this. And when you have different level of judiciary, like in the EU, the Court of Justice and national courts, how do you think your claim can work? The first question is this. The second one is referring to the Euro crisis. In a recent this Court of Justice, the Court of Justice says, we are dealing with very technical issues, economic one. So I trust the ECB. I give the last word in a certain way to the central bank. So in this way, in this decision, the Court of Justice admit that they have not the technical competences to enter in economical questions. So I think this can be interesting.
Yeah, just to add sort of a sense of skepticism about the judicial review, there is some research that testifies that judges are under extreme conditions inclined to be actually quite risk averse, which means that usually when the judge is facing a national security argument in competition with human rights arguments, let's say by NGOs which represent minorities, the judge will incline to prefer, judicially speaking, national security arguments. So this is one issue that I think should be taken into account. Yet I would like to say a word about experts. Usually emergencies do mean uncertainties, very basic uncertainties, what I would call epistemological uncertainties. And under those conditions, most of the experts would actually represent national security interests. Now, it may differ in Israel and the US, because in Israel, the number of experts which are outside the security establishment would be quite minute in times of emergencies. But I would argue the same similarly about other countries. also, I think that the myth about experts, which I mean might be some truth into it, but we also have to take into account that experts usually or not infrequently articulate national security interests. So,
Andreas.
I'd also like to come back to the expert question and give it a slightly new drive, because you were talking about the constitutional mindset, which they should possess in order to draw the public's attention to the slippery slope which we find in the normalization of states of emergency. So when I understood your paper correctly, you were especially talking about terrorist threats and the security state. So there we have the problem that the slippery slope that fundamental rights and liberties are damaged on the long run. And I wonder if, when we are talking about experts, we should be talking about public intellectuals, like which possess this sort of constitutional mindset too, and which draw the public's attention and which can initiate a public debate on this slippery slope and the problems which arise with the normal emergency. And it's fascinating, for instance, to see in Germany, where I come from, that judges from the Constitutional Court increasingly act as public intellectuals. They give interviews, they do public debate, current judges and former judges. Maybe because Germany does not really know true intellectuals, apart from Habermas and some others. So I wonder if that couldn't be a good drive for you.
Got it.
I think that it's important to think that bring out the fact that, historically speaking, the executive plays a privileged role in the form of police power and security, public order, health, in promoting and safeguarding cohesion of state and the issues of security, intelligence, effective diplomatic action in terms of relations with other countries. So we have the basic forms of emergencies that occurred recently. Take it the coup d'etat in Turkey, the attempt of the coup d'etat in Turkey, the refugees in Syria, or terrorism in Greece, or the economic crisis. This cannot be addressed and resolved, mainly by the judiciary or the legislature. These are fields and problems which require executive action, I think. The second point, however, is that once we give a positive answer to the issue of the executive action, then there is the question of limits, abuses, and the effect and the usage of the emergency as a sham, as a pretext. And there comes the legitimating factor and the guaranteeing factor played by the two other branches of government, which is the legislature, which will democratically legitimize the decisions, and the judiciary, which will protect the system and society from the grave risk of sacrificing the innocent person for the sake of the collective interest. In my mind, it is important to draw a distinction, differentiating the role of the executive, which is instrumental basically, from the normative and legitimizing role of the two other branches of government, which is the legislature and the judiciary.
Yeah, 2 points to emphasize. One connects to I don't think there is such a thing. Okay? it's either exceptional, okay, when politicians or policyholders or power holders step out of the rule of law totally, or it's part of normality. And I think that many things that we relate here are not related to emergency. They are related to different changing circumstances, changing preferences, which bring about anti-liberal legislation, but with regular rule of law, formal rule of law. So I think that, we are all in our mind thinking about national security and the problem that works with it. But if we look at disasters, for example, there is a big fire or there is an epidemic, we will not go to voters or to the legislator to debate whether we should take certain measures. We go to the experts. So I think that we should also consider experts. This is the second point, the distinction between expertise and preferences. Okay? From our experience, Israeli experience, sometimes even the national security experts, and I'm not talking about the less sensitive fields of natural disasters and economic meltdown, I think hybrid. But even if we talk about the national security, sometimes the moderate voices are those of the security people. Okay? If we talk about demolition of houses, preferences of politicians advocate using this method. The experts, the security forces say, no, this is actually counter productive because it will actually promote more hatred and more terrorism and so forth. So I think that the expert thing is not to be bypassed. I think it's an important thing. And as Amnon said, I think judges are very important experts, maybe on top of public intellectual, also human rights, and they can criticize or balance or review measures as affecting what is really affecting justifiably or not justifiably. But they cannot be really experts with regard to the switch of emergency, whether it's within the formal rule of law or outside of it.
It seems to me that indeed, crucial is the definition of the state of perception in other considerations with solvent. And I like the concept with this, I like emergency and with the exception. And I think the important thing is to read the connection to the law. Because there's one thing that it's a small thing, but even within the system of emergency, which needs the exception, is that it's because it's something that is unpredictable, unpredicted, something that appears, it hasn't regulated before. However, from that, we also have the scale that in normal situations, in emergency situations, the legislator takes the normal rule of law situation, the substantive, the legislature takes into account it cannot predict everything. And here I just think especially about the German police laws, which is especially avoiding danger laws, like the criminal punishment laws, the nature laws, which allow for the police to take any measures possible to avoid danger from public security. And in this it's very clear that even the unexpected is allowed. However, the important connection is that I am still bound by the informal and especially and the idea of proportionality. So no violation of human rights. But within that frame, everything is clear. And the judiciary is only there in order to decide ex post if that actually occurred. And the police is acting always ex ante perspective, and the judiciary is only the ex post perspective. I was thinking though that here within the system of the rule of law, you do have always this assumption that judges, they can be asked, especially in criminal cases, for example, in the arrest event, in order to decide prior to the case. However, in there you have that in a case of emergency, the police can decide themselves, and it's the judge who then ex post kind of the first And the other thing was the loss declaration being one of the most extreme emergency states the war. And actually, I think in the last, I don't know when the last war has been declared. I think the United States have been declared wars as the Second World War was declared since then. There's no official declaration made. And what that numbers makes it clear, again, there is a certain point where the public knows all humanitarian rights because we live on conflict. No one knows who is actually fine with that. Which institution says that. However, somehow all of a sudden, then there's a normal international context. And here, indeed, I thought it was just an interesting connection between the no declaration. All of a sudden, everyone, it is somehow publicly declared on conflict. Through media, or you never know when they actually did that. And it's a situation itself. So, in this regard, I think maybe the comparison made to the reading of the declaration in this case. I'm not sure if the judiciary, but I think it's more judiciary and argue this is more a cost perspective more than
MING-SUNG, you have about 45 seconds to address all of it, and while you're global warming too.
Basically, I think there are the questions of how to centralize around two subjects. First, the expert. Second, again, the known fact or state of emergency and the state of exception. So for expert, I think I think he made a point. I think one thing I draw from the discussion here is that we may need to draw a distinction between the executive power as the expert of national security and the executive power having privileged the status, traditionally perceived the privileged status. So expertise doesn't come with privileged status at all times. So I think this is also Alice's contribution to the identification of the location of the real expertise in national security. Norm and fact again. Yes, I don't think I'm in a position to answer the question. I think I just raised some issues here as Anna's pointing, Anna suggested. Even in a rule of law state like Germany, in ordinary police law or other legislation, there is always a general clause authorizing the police or other public authorities to take some exigent actions. The only difference is that it's still subject to expose to judicial review. But the question here is still remains. The question is when it comes to those unexpected situations, would we see something like the recalibration of the law? If so, yes, we may still have an overarching framework governing all situations, but the substance of the rule of law, whether it remains the same, I'm not so sure. And I think I should stop here in the interest of time.
Please join me in thanking Ellie and MING-SUNG. First break from 11 until 11:30. Please feel free to get coffee and refreshments, and we'll reconvene at 11:30 sharp for our second session.
יש לנו רק את זה, נכון? צריך לראות למטה.
You were dying of the notes. I think that went well, right? With the video?
I think so. We're still online. I don't know if to stop it or not.
What do you think? Can you pause it or maybe
I don't know how to pause this. We can redo it, for a second.
maybe leave it, I think.
If it works, don't touch it.
אמרתי לה, כן, איזה שיפור, איזה מדיעות סשן, כאילו, משהו כזה, לא ידעתי שהיא באה כדי שהייתי עושה כזה אחד מהפעמים, מדיעות, שעה שהיא כאילו קראתי מהספר, זהו, אני לא ידעתי.
נראה לי שאני לא רוצה לעשות בשבילה.
לא, ברור, אבל זה... בואי אני אסתכל לך, ואני רוצה גם לשים את זה, איפה אפשר לחלק לאנשים כל כך?
מה זה? לספר שלה.
רציתי זה בתוך הפולדרים, זה כבר קולט.
אפשר לחלק לאנשים, אולי כדי בהתחלת הספר.
מה את אומרת?
קרין, שימי לך פתק שידעו שזה את. לא משנה, אבל עכשיו במינגלינג שידעו שזה את. כי אני חשבתי אולי באמת בהתחלת הסשן השני להגיד לכולם שיש את ה...
ואני אגיד משהו, אני בתחילת הפעם הבאה...
ותגיד שקרין איתנו, תודה.
כן.
רגע.
לא, יש לך להגיד.
אנחנו עושים את זה, אני נכנסת למיוט.
Yeah. Karin? All right, guys, welcome back to our second panel, and this one will focus on constitution making under extreme conditions. And before we start, I just want to have your attention to this new book, Emergencies in Public Law, authored by Karin Levy, that we're just discussing. If you, I have an autograph. I think you should feel free to come to her during these next 2 days and talk to her about your project. You might benefit something. And I also allowed myself to put this voucher. You get 20% discount if you buy it. And this book was published with the help of the Minerva Center. So I think this could be a useful opportunity for all of us. And without further ado, I will continue to this panel. We'll begin with MANAR Mahmoud's paper. MANAR is from the Hebrew University, and her paper deals with the challenges of reconciliatory constitution making in Tunisia, and the Dean of the Law School, Professor BARZILAI.
Thanks very much. I enjoyed very much reading MANAR Mahmoud paper, which is based, I think, on your PhD. And I'll make a few comments. First of all, it's an article which is very well written. I mean, there is a theory and case study selection, and I will say more about the major conclusion, which I would refer to the article. So first of all, it's not an article about constitutions. It's an article about constitutional process of constitutional making. So actually, MANAR is talking about the process of constitutional making and its possible ramifications on national reconciliation, and I would add also its repercussions on building a democracy. And she's referring primarily to two case studies in the Middle East, in the Arab Muslim Middle East, which are Egypt and case studies, what a constitutional process or a process of making a constitution. And she's arguing that her main theme is about the reconciliatory power of constitutional making. So it's not really an issue whether a constitution will be drafted at the end of the process. And it's not only about what is written in a constitution, but MANAR is arguing that the process of constitutional making will have conciliatory repercussions on a specific society at stake. Now, I think that one point further about the main argument of the paper, MANAR about the political body. She's actually arguing that society is inclined to be conflictual, that different stakeholders in any given political setting may have different perspectives, different ideologies, and different interests in the process of the constitutional making. And through that perspective, she is looking into the cases of Egypt and Tunisia. Now, the cases are, however, very different. In Tunisia, what MANAR is showing, the process of the constitutional may generate democratization in Tunisia, much more voices about gender equality, much more voices about the need in democratic elections, and more constraints on Muslim extremism in Tunisia. And also what MANAR is showing, that the process of constitutional making allowed Tunisia to move from a presidential authoritarian system into a much more open society, much more democratic society, constraining extremist and radical forces in Tunisia. Standing, the Egyptian case is completely different. And I would add partly because of an issue that maybe the paper is not unveiled sufficiently. So in Egypt, what MANAR is showing, the process of constitutional resulted in, at first, much more power to the Muslim Brothers, in much more power to radical extremist Muslim factions, and in the second stage, much more power to the Egyptian military, which actually in some way, I don't know if this is how MANAR would phrase it, is abused the attempts to use the Arab Spring in order to have an Egyptian democracy. I just had an anecdote that when I was teaching at University of Washington, one of my PhD students, she was an Egyptian journalist. And when the Arab Spring erupted, actually, she was very invigorating youngster. She burst into my office and she told me, now Egypt is going to be like Israel. We are going to, I mean, she meant to give a compliment. She said, we are going to be a middle class, flourishing, liberal democracy. This is how she saw Israel, maybe because she was my student. But I tell that anecdote because later
Haifa or Tel Aviv.
she was later on she was highly disappointed of what happened in Egypt, and I think that your article actually reflects how Egypt has been different from at the end of your paper, and this was missing in your paper. I think that you need to have a theory at the outset, but which you may have at the outset of your paper, but not at the end of your paper. You are ending your paper in some lessons about why it failed in Egypt, why Tunisia became much more democratized because of open discussions about constitutional making. In your main, we emphasize it, your main point is once you have under extreme conditions a process of constitutional making, you may have a much more open space for different political factions to come around, articulate new voices. It failed in Egypt, and unlike you, I don't think that it was necessarily because of the Muslim Brothers. I think that it was mainly because the Egyptian military is different from many armed forces that we know in comparative literature. First of all, the Egyptian military would be the strongest economic organization in Egypt. It is obviously politically very effective, and I think that in your paper you may wish to put more emphasis on how the Egyptian military actually was highly concerned with the process of constitutional making. At the end of your paper, I mean, you are trying to draw some lessons what should be done in Egypt, and I think that you are very disappointed of the Egyptians. They should have read your PhD. Academics don't try. But what I was missing at the end of your paper is theoretical conclusions. And I would like to contribute, I think, one very important theoretical conclusion, which is basically embodied in your excellent paper. And this is the following conclusion, that in extreme conditions, do offer an opportunity, a political opportunity, for a process of constitution making, possibly reconciliatory ramifications, notwithstanding with some unexpected results. So I think this is what your paper to us to understand, that extreme conditions may invite new opportunities for constitutional making, notwithstanding some of the results would be unexpected. I would like to offer maybe four very quick suggestions as well. Firstly, I think that like in Egypt, a process of constitutional may create spillover of conflicts. This was actually what happened with the Muslim Brothers in Egypt, suddenly the Muslim brothers became the power elite, which they have not been, I think, since the early 1950s. So this is one issue that we have to take into account. Secondly, often constitution making be an elite-driven force. I think that your general view of how constitution have been made is highly pluralistic and liberal. But in fact, many of the constitutions have been made or created by elites because of elite interests, not necessarily because of kind of an open society for pluralism. Thirdly, I will the paper is excellent. Again, it's very well written, very organized. I think that it may benefit from some European case, like France in 1958, which is a constitutional making process. But again, I think, but I'm not expert on France, obviously, that this has been an elite-driven process, and I think that you should look into some Asian experience, like Korea and Taiwan. How constitutions have been made, while, especially I think South Korea, maybe not as much Taiwan, but South Korea, moving from a military rule into a democracy. So I think that your paper is so powerful, and it may relate to other cases above the Middle East. And in the Middle East, I think Israel would be actually quite an interesting case to engage with, because in Israel you have an ongoing process actually of a constitution making. You know, the Harari Compromise, 1952, I don't think that somebody seriously was considering the Harari Compromise to become a constitution, because the power elite didn't want a constitution to be drafted. And then you have, you know, Supreme Court justices like President Barak, who is going to talk here later on today, and he argued there is a constitution, which I think it's a doubtful argument. So Israel would be, I think that you have a very strong, intriguing argument in your paper, and I think that you may wish to use additional case studies about the fascinating cases of Egypt.
And Mana, would you like to respond or guide the participants at some point, or feel free to say whatever.
Thank you, Daddy, for your comments. I have to say that this paper is still at the first stage. It's really drafted and actually it is a part of large that I'm doing during my post-doctoral at the University. And I wanted to say that the Tunisian and the Egyptian case wasn't the cases I dealt with in my dissertation. Actually, in my PhD dissertation, I tried to develop a theoretical model that I have to say that I am political science. I am not coming from law. So my analysis of constitution making mainly concept perspectives of social issues and political processes. And I tried in my PhD dissertation to develop a theoretical model that then the way that constitution making can promote reconciliation. And I analyzed 3 case studies, South Africa, Canada, and Belgium. This research, I'm trying to develop the theoretical model through the analysis of these another 2 issues. The theoretical model says that constitution making process can be reconciliatory constitution making. This is the what I call the theoretical, the name of the theoretical. Well, it entails 4 sets of conditions. The first set is the transformation in the regime, from hegemonic one to a regime that include the other groups, different groups. Another variable is the transformation also of the political culture from hegemonic one. The second variable is the way the different group actually have active participate in the constitution itself. So I emphasize that constitution making must be a participatory one, and not a constitution making that only elites take part in establishing the constitution. And also, constitution itself deals with the rights of the different groups, and especially their collective rights. And the fourth condition is how the constitution making actually deals with the issues related to the conflicts between the different groups, like establishing a truth commission, committees that dealing with the issues relating to conflicts. And in this, trying to understand the constitution-making process in Tunisia and Egypt. And one of the problems actually that I have at this stage is how can I reach the preliminary materials in order to analyze the constitution process. That is for now. Thank you.
Thank you very much. So we'll open it to other participants. Feel free again if you want to talk, just say your name so I can see. Richard, I'll make mine. Go ahead.
Really enjoyed reading this paper, and also hearing you talk now about your larger project, your PhD project, which I guess includes South Africa, Canada, and Belgium. I'd really like to see those. In fact, I was going to refer to two of those cases in my comments. I guess the question that I have, one question that I have is whether on your definition of reconciliatory constitution making, whether all constitution making is not reconciliatory constitution making. The 5 points that you make here don't seem to me to distinguish sufficiently the Tunisian and Egyptian cases, for example, from the Canadian one that you mentioned, or the Japanese one, or even the American case. I think under your definition here, your understanding of constitution-making, the U.S. constitution-making experience from 1787 through 89 is part of that. Now, I don't know if you would consider that an example of it. You might say, yes, it is. But reading the paper, I did think that you would say that that's an example of reconciliatory constitution-making. So I guess the question or suggestion that I have is whether you might not want to more narrowly define point A that you have here, 5 points for what the process of reconciliatory constitution making entails. Here you talk about the constitution making process having the aim of being a solution in part to an ongoing conflict. I think perhaps you don't mean conflict in general, because that's, there was conflict in the design of the Canadian Constitution, the US Constitution, the Japanese Constitution that Gad mentioned. But maybe you're talking about the more specific kind of conflict. Maybe it's ethnic conflict, maybe it's something more than just conflict in order to distinguish what I think is conflict in every single case of constitution making that I know of, in contrast to the ones that you want to focus on. So that's just the first point I wanted to make and ask for your reflections on if there's time. Well, until other people decide to talk, I will give some comments of my own. I just want to focus on two of these variables you mentioned, and I think your contribution could be quite important in relating to these two. First is participation, and I'm just curious. I mean, now
we know that there's a global trend of allowing the people to participate in constitution making. About 40% of all constitutions were adopted by a referendum. And I was just wondering, what kind of participation do you mean? Do you mean just this soccer stadium participation that the people applaud, they say yes or no in the end, or you want the people to be involved before, during, and after the constitution making, and in which way? So this is one issue. And the second one is about the fourth part of the regulation of how the constitution regulates the major conflicts between the different groups. And then here I refer you to this idea of gag rules in constitution. Sometimes we prefer not to decide things in the constitution. We say, okay, we decide all of these issues are so contentious, so we want to first finish this enterprise, this constitutional project, and in 10, 15 years, when things come down, we'll settle into the other stuff. So just where your theory fits within this idea, because if we talk about reconciliation and the Truth Commission, it goes the other way around. We want to open things up, right? Another point is the role of militarism, which is obviously crucial in the Egyptian case. And I would just refer you to the work of Osandro Orr, who has two major works, one on the democratic coup d'etat, and the second one on military as protectors of democracy. He also mentions Egypt, and this obviously goes to Tillman's paper. I guess we'll talk about that as well. Two final things. What's the role of external powers? Zoran Oklovchich has now a book on With the People. It says beyond with the people. It says now this constitution making around the world is not only within the state. There are many external powers involved. And how does this fit with your theory of constitution making? And finally, would you agree that your paper actually sits perfectly within Andrews' Arado conception? Andrews Arado has this new book on post-sovereign constitution, where he says, okay, we need to put emphasis on pluralism and interim constitutions. So where does that fit within? I think it's quite fits. And the final thing is, John Ulster famously said that if you want to have a successful constitution making, it should be behind closed doors, no transparency. The politicians need to bargain and get the agreements. But it seems to me you should say, no, it has to be open. So just how it fits with John Ulster's view. You don't have to answer anything, you can just ignore everything I said. Food for thought. Yes, Amma, please.
Sure. So I wanna switch the discussion and view it from the opposite side. I want to begin by saying that I think that that your work. I just got an email from Hani Lerner that she should have been here, and she wishes that she could have been. It's a wonderful work because because this work tries to look at very complex processes, not necessarily from a political science point of view, and then it for us lawyers, it's really crucial to take it into consideration. Though, is about the theory. Is this a descriptive theory saying, to the extent that I see as a political scientist that these conditions are met, therefore, I have a situation of reconciliation, or is it a normative theory, a prescriptive theory saying, normatively, as a point of justice, to the societies should aspire to meet those normative conditions, and therefore, whether they kill each other in the streets later on or not, that's beside the point. I would then say that it has been a reconciliatory process, and you see Norm's business comes in and bites us from another perspective. To illustrate this, I wanna suggest that inherently in constitution making, there's actually a non-conciliatory process going on. Why? And this goes on some of Ellie's work. So I've been pointing to the work we've done on distinction between. So in constitution making, the price is actually higher because it's more difficult to amend, and it lasts longer. The constitution making phase have greater incentive to insist on not compromising, because to the extent that I compromise, then I'm it's not just a compromise. I bargain. If I insist, then I gain a lot of benefits down the road because it's not dependent, it's more difficult to change. So the more you touch on those issues, the more risk you run of bifurcation and polarization. This is public choice theory. Add to that the identity element. Is this constitution? Is it us? Is it them? Is my voice being heard adequately? Are my symbols represented adequately? And look at the Canadian example. In Canada, in Quebec, still today, there are voices of should we or shouldn't we? Okay, you're Canada, come on, you're in Canada. What do you care? No, but we're a distinct society. And to the fact that we weren't recognized as a distinct society, we are going to fight for secession. What does it mean? We don't care. We're a distinct society. And they're less, in Canada, it's my PhD is from Canada, so I can make fun of Canada. I love Canada. But, in Scotland, you could say, well, we want to be part of it's more. So I think that the starting point of the analysis should be that constitution making isn't, but rather is the powers to break into various units is more present. And that ties back to Gadi's comment, and with this I conclude. Part of the reason that in Israel, and Shuki Segev has pointed to that, part of the reason in Israel we didn't have a constitution is because, it's not the only part, but because some people realize to do that, so it's better to leave the big questions undecided and form this, whatever, process of nation building or society building or whatever you want to call it, precisely because it's too risky. Even if we've done the participatory and record, don't go there.
Andrea.
Yeah, thank you for your great paper, which I really enjoyed to read, and I'm that people might see both of our papers as contradictory, but I really write riches because I don't think they are. When you are talking about this making, it is, to my mind, based off public reasoning in the Habermas-Rawlsian sense. So people should do public reasoning about the rules the society wants to have for itself. But in certain situations, as I argue in my papers, are not in a position to do this because of revolutionary turmoil and things like that. And then, if you still want to abide to the principles of public reasoning, some external help might be necessary. Processes, external agencies, institutions which help such a reconciliatory constitution-making process. So I think there are really elements in both of our arguments which fit together quite well. So that's just what I wanted to add.
Guru.
My understanding of the term reconciliation, I have four loads of problems in the sense that reconciliation generally in a post-conflict situation, as it's used in civil justice literature, would indicate political compromise, a political compromise on what is achievable at the given situation. So the given situation might mean that there are actors, depending on how the conflict falls out, who might be stronger and the other weak. And the notion of justice, whatever version that you hold, might not actually reflect in that sort of banner of reconciliation. There's so much of debate about the kind of reconciliation that has been also in a number of other. So my question was, is there a substantive notion of what you consider to be reconciliation, which you think in these situations the Constitution should reflect? The second is building on constitution-making processes, meaning actually non-reconciliation stuff. For example, commentators on Sri Lanka's sort of 30, 40 years of experimentation with state reform. State reform, whenever there has been a constitutional reform process, that led to hardening of stances on both sides. That both sides actually take up very rigorous and rigid decisions as to what sort of constitution should be made. Talk about compromise. So every time, so this is Professor Jayadeva Young, a renowned political scientist from also known widely across South Asia, who talks about every time we have a state reform process, makes the subsequent state reform process even more difficult because of the hardening of decisions that seems to permeate through. And so constitution making processes, the experience in some of these deeply divided or context might actually tell a different story. And so and that is why substate actors, because they are concerned by means majority structures. So, for example, we hear all the time a solution that is acceptable to all. A solution that is acceptable to all would, in the kind of procedural democratic understanding that we have of democracy, would mean the minority somehow commits a minority, and that might not necessarily represent concerns about justice. I mean, everybody makes compromises. Isn't constitution making? I mean, do we have? That is where the process element comes in, because there is so much of talk about public consultation in Sri Lanka as a movement just completed a public consultation process. So you have a report, which is a consultation process that says this side says this side says that. So let's come up with something in the middle. And if you look at what they construct in the middle, they look at some very incremental, and this is why I have a problem with learners' work of incremental. I mean, whose side does incremental constitution take? At the end of the day, it's very close to the status quo damn we are pushing us forward, which then leads to the substate actor being fundamentally unhappy with some about further
Thank you very much. Nicholas. Yeah, I mean, I want to go back to the discussion that we had before about conciliatory and reconciliatory, and reflect a bit on what you said about Hannah Lerner's work, which I find very useful. I think another stream of thought and another stream of consider, I'm sure you have already, but it might be useful for your paper, is this idea that comes from Northern Ireland and Scotland, from the people like Neil Walker, Neil Malcolm, and Kristen Bell, who actually what they say is that in a way they go a bit beyond this idea of whether we have a conciliatory or non-conciliatory constitution making. They say that in post-conflict societies, the constitution works in a way as a space to negotiate all the time the conflict, that we cannot solve the conflict. So what we do is we create a public space, create a constitution in order to negotiate all the time the conflict until we reach a conciliation and we to a more cohesive constitution and more cohesive state of organization. So, although it's perhaps not as comprehensive as your proposal, I think it's an interesting point of view, especially coming from the Northern Ireland.
Yeah.
In constitutionalism, this process of evading the divisiveness and this abstraction at a higher level of recognizing universal rights and dignity will somehow lead to what Carré de Malbec was calling la monade humaine, the human monad, which somehow absorbs all kinds of and somehow puts in the background all kinds of things. My question is, in the context of Egypt and Tunisia, what is the level on which people can discuss and try to find a common agreement, given that there are deep divisive issues in terms of privileges, in terms of religious conceptions of the state as opposed to secular
expertly on the situation in Middle East or Tunisia and Egypt. But I think I learned a lot from this paper. I just, in contrast to the normative tone I found in this paper, I would like to put the two cases in a more realistic light in the following way. I think you mentioned the case exemplified the reconciliatory model in terms of the elected Jena party, the Islamist party's willingness to involve other forces in the constitution making, and in contrast, in the Egyptian case, Muslim Brotherhood was not the case, and this led to its own doom. But in your paper, I found you noted in the Tunisian case, the Islamist party only gained 40%. Also, a majority, of course, that's the majority force. But with 40% of majority, could it play the dominant role in that process? And I'm not sure the percentage point of votes garnered by Egyptian Muslim Brotherhood in that case. So I just wonder whether the reconciliatory associated with Tunisia has more to do with the real politics than to the normative aspirations involved. Just a question.
Yeah, just a remark with regard to going back to basics. Basic political theory, it's not reconciliation or non-reconciliation. Basic political theory sees constitution as a social contract. It has to reflect not majority, but central decision. What we are witnessing in the American case was the American constitution also well. Maybe not totally, because it was a consensual process. Okay, now America is exporting to the world that democracy is election majority, and this affects the process that we see in Tunisia and especially in Egypt. If you hold the idea that not a constitution unless it is consensual by all the peoples, okay, then of course whether we will see reconciliation or not is a important thing. And of course, we have also the equilibrium between positive analysis and normative analysis. If you require consensus, okay, then you positively can predict that the constitution will hold for a longer time. We didn't see it in Egypt. Egypt was not a process of social contracts. It was a process of majority. And I think this is an important point when we think about constitution. Of course, under extreme condition or uncertainty, the chances that we will reach a consensus are greater. But we have to stick to the point that constitution is a consensual process and not majority process.
Should I add now? You have about a minute. You don't have to answer anything. But... Oh, sorry. Do you want to say something?
Okay, thank you. I just wanted to say that I don't think that every constitution making is a reconciliatory one. In some cases, like the Belgium one and also the Canadian constitution making, when we are dealing with the relationship between the original people and the other Canadian, the constitution making process, for me, at least, wasn't a reconciliatory constitution making, because case the constitution making actually was part of amendments that took place over the years, and actually it leads to more conflict between the balloons and the French, and also in the Canadian case that people still claim their right for self-determination. And that's why I don't think that constitution making sometimes actually can harm the rights of different groups, especially when we are talking about minority groups or about groups that are don't have the power to claim their rights. And I wanted to say that my understanding of constitution making as a participatory one, that is constitution making that it is more open. It is conducted of several committees, and not only the people can participate at the final stage of the constitution making, like saying yes or no in the referendum or something like that. That's it for now. I don't have a lot of time to answer the comments and the questions. I mean,
All right, great. So yeah, you have a lot to think about for the paper. Please let's thank Gadi and Manar for this. And we'll quickly continue to the second paper by ANDREAS BRAUNE about authoritative constitution making in the name of democracy. And the discussant would be Professor REICHMAN, a co-director at the Minerva Center.
Thank you very much. And thank you, Andreas, for a wonderful paper. It was a pleasure to read this. I want to also thank the organizers for the wonderful pairing of those two papers, which, as Andrea pointed out, we going at completely good, because the starting point of Andrea's paper is that we are all aware that constitutions contains, the anti-majoritarian paradox is there, that, constitution in democracies should be about the will of the people, although they restrain the will of the people by the unelected, etc. So the people restrain themselves, and that's a bit of a puzzle there. What Andrea points out, that there's a further puzzle, which focuses on constitution making, especially in transitional justice or in transitional societies, or what he terms in one place in the paper, traditional polities or something. So when you move away from authoritative regime, which is the thrust of the paper says that it is important to talk about this primarily in transitional situations, because if there is a constitution making a different draft of the French constitution, then okay, it's not the main problem. The main problem is when you move away from authoritarian regime, then what you see de facto is an authoritative constitution making. This is what you see happening in various, and when you see less of it, the constitution is less stable. So it might not be a bad idea, normatively, to suggest that there should be a component, an authoritative component within the constitution making of a democracy. So there's a paradox between us wanting a democracy, but the way we achieve a democracy through a constitution is by using less democratic means or authoritative means to get there. That's the thrust of the paradox that Andreas has identified, and it's neat. It's a nice way of looking at it, I think. So the reasons behind this paradox are social reasons. They could be summarized, I think, in two ways. One is an agency problem notion, because during constitution making, you don't have a space outside the process. People who do that are going to participate in the process the second after the constitution is ratified, and they have a vested interest in the outcome. So they have an agency problem. They want to get a larger piece of the pie for themselves. What part of the process they play, they still want to get a larger piece of pie from them. And so you have an agency problem, they're built in, and you have a mindset problem. The mindset problem deals with the fact that it is, and that ties to the theme of the conference, it's an extreme condition in the sense that it's a struggle. Constitution in post authoritative regime do not just emerge. You know, oh, you wake up in the morning and all of a sudden you realize that communism was bad or dictatorship was bad. It was achieved through struggle. And therefore your mindset, your mind frame is a mind frame of struggle, of belligerency. And under those constitutions, under those circumstances, it's very difficult to achieve this Habermasian condition, as we've talked about a second ago, of calm public reasoning, where you talk to the other and you see the other and you negotiate with the other and you talk about public reason. In real life, because of the mindset problem, it doesn't happen. So this is basically the thrust of the paper. And then the paper continues to offer three distinct to accommodate this authoritative input. One is to refer to God. This is the divine intervention. We all believe in God, or let's seek some sense of what Jonas talked about before. This high common, and the high common denominator could be, it's not a low common, it's the highest common, highest level could be God. So we were created under the image of God, and therefore we can live together. Thank you very much. Let's get the Pope blessing, and then we can. So this is the divine intervention. We can talk about experts, what we talked about before. Let's have the assistance of experts to negotiate, to draft, to have very serious input. So we go to experts, and then we can talk about fine-tuning what the experts have done. But basically, the structure is done by experts. South African example is with the interim constitution. You go to a law professor, you have a draft of the constitution. It's an example. Or you go to totally external input, such as in Germany or Japan. These are the famous examples, but other examples like in Kosovo, there are cases where we have to draw on external forces. They are neutral, you trust them, they go in, they help you. There was a whole industry in the United States of helping those poor people of everywhere, basically, but mainly Eastern Europe, to draft a decent constitution when they emerge from communism. And therefore, this external assistance is a way to somehow mitigate this authoritative dimension in order to assist in moving away from an authoritative regime to a more flourishing democratic or liberal democratic structure. I have this bad past that we also have to walk away from, and this bad past include not only the authoritative regime, but the authoritative way in which our constitution was made because of this authoritative regime. Okay. So this is the Machiavellian point of, all constitutions or all states begin with a certain crime, and then you have to move forward afterwards. This is to draw on Machiavelli. Now, this is the description of the paper. It's a wonderful paper. I have very few, the remaining time I want to on three points that Andreas made that I think are worth further considering. One is his, I think, interesting claims that constitution making is unique because it's outside the polity. This is drawing on Boudin or on Hannah Arendt's work that's saying that when you make a constitution, the origin system of a polity, when you make a constitution, you don't make a constitution, you make the polity as you make the constitution. So it's a space outside which is unique, and I think it's worth considering with respect to our perspective. What is an exception? How should we think about the continuum between normalcy and exception? And also, I think what's warrant further consideration is whether law is part of the solution or law is part of the problem. Again, because this legalized process of constitution making could be part of the problem if you have to abide by ordinary rule of law. And Andreas begins his paper by saying, well, if under an extreme condition you can have an exception, why not have an exception during the constitution? So that's the rule of law. Is it part of the solution, part of the problem? Now here, I want to say, as I said, three things. First of all, our understanding of democracy. And as Eli pointed out, this notion of consensus, democracy is about rights. I mean, if you want to be serious about democracy, stems from rights. So this whole business of a paradox of the sovereign restricting the sovereign itself, I think, can be better contained with a robust theory of rights. And I think, and this ties back to the work we've just heard, and where you said that actually they're complementary. If you, to the extent of rights, I think that some of the theoretical components are mitigated. The second point I want to make is the move from separation of powers and the authoritative thinking of, well, it's not the people, okay, which is, okay, so I want us to move away from Habermas to Luhmann, okay, if I may. Sure. So Habermas had the idea of public dialogue, where Luhmann says it really can't happen because it's system specific. Dialogue happens within systems. And one system is a bureaucracy where you locate the experts. And the other system is politics where, power, and it's okay to have interplay between, in fact, it would be highly surprising if we didn't have interplay between systems. So actually the conundrum isn't such a great conundrum if you move away from Habermas to Luhmann in that respect. And if you do that, another conundrum sort of loses some of its viciousness, and that is the distinction you make between constitutional making and then constitutional implementation. You draw a distinction by saying, constitutional making, we have a problem with it, or once we move away, proceed to be more robust. But if we look at the life of a constitution in actual fact, in reality, you have a lot of experts playing a role, and judges playing a role, and the market plays a role, and various systems playing a role. So it's a bit, Luhmann would say, it's a bit wrong to expect the Habermasian all-encompassing public discourse to prevail when you actually have very non-democratic, but Luhmann would say system-specific discourse going on during the life of a constitution, not during a constitutional making itself. The last 2 points I want to make very briefly, one has to do with Tom Ginsburg, introducing Tom Ginsburg's work about the notion of, in South Asia, and this idea of the agency problem and the notion of insurance. Tom Ginsburg says, and it points to your part, why would I want to join in a process that I restrain myself? So Tom Ginsburg says, especially in post-authoritative countries, when you don't have a mindset of democracy, you want to insure yourself because you know that if you lose, the other guy may win and may change the rules of the game, so he will continue to win. So therefore, you want to have some suprastructure that is very difficult to amend, or more difficult to amend, before the big. This is why you would have a constitution. Now, I think it's a friendly amendment because I think it fits well with your understanding that in order to create this suprastructure, sometimes you need external help. So it's a friendly amendment to consider also Ginsburg work. The second amendment is to draw on Gadi's previous comment, and with this I'll conclude. Your distinction, you seem to work with a pretty set idea of what a constitution is. It is, however, there's a different way to look at it in terms of a process. And if you do that, then you must recognize the notion of interim constitutions. So once you recognize interim constitutions, there you can say, well, with respect to the interim constitution, maybe you need this help or this divine or that. But you move away from an interim constitution to a full constitution. Well, we are still in the process of having an interim constitution, according to some.
In Germany too.
And in Germany, and in many, in the EU, is the EU a state, not state, but is it an interim constitution? So the constitution as having interim, and then you have constitutional moments within this constitutional process, then I think it enriches and further problem notion of just the constitution making this moment as this, you have a fixed idea of this is a constitution, and you seem to work with that. But again, thank you for a very interesting paper, and I'm sure we'll have an interesting discussion following that.
Yeah, thank you very much for really greatly summarizing the paper and for all this input, where I really don't know where to begin to react to, and I didn't know the work of Ginsburg, so maybe you can give me some literature which might help me there. I'd like to add that the intention of the paper is quite modest, and I'm aware that replaces one dilemma with another. So we have the dilemma of the sovereignty of the people. We're supposed to draft a constitution which in certain situations lacks the possibility or the ability to do this in a effective and ideal way. And then the problem which arises, especially if it's done in a majoritarian way, is that processes of constitution making can collapse in the worst case in civil war. When also the monopoly of force of the state collapses and things like that. So there are certain problems attached to democratic constitution making in certain, especially revolutions. And the argument I'm making is that in those situations, some recourse to external authorities might be helpful to, or even internal might be helpful to not to have those problems you have with the democratic constitution making process. But then you have another dilemma. You have to be sure that those authorities you address or you include into the constitution making process have that constitutional mindset and let loose of their power during that process or after that process. So you're getting rid of one dilemma by moving directly into another one. I think it's not a problem of which
it's not a bug, it's a feature.
Yeah, it's a feature. And second, the whole paper is formulated within a political theory framework, which draws a lot from normative political theory, Rousseau, Aristotle, John Rawls, Hannah Arendt, and so on and so on. So it sounds like a normative theory that I'm suggesting that those authoritative means are to be used. But actually, what I'm trying to do, and I'm at the start of this research project, and this is also a reason why I don't have any case studies in it. First and above all, it's also an empirical hypothesis. So I'm wondering if constitution-making processes, which rather tend to use authoritative means, are more successful in establishing rule of law and democracy. And this must be found out by empirical research and by historical evidence. But that's what I'm planning to do. But I currently do not do that yet. So thank you for this Luhmann suggestion, which I find really interesting. It does not really fit very well to the normative theory framework I'm using, but still, I'll be thinking about that if that might, put some of the normative weight out of the paper. I mean, that might be a good solution to do that. Yeah, that's all for now.
Alright, if there are any yes, please, Johannes.
I read with real joy in your paper the originality of it is in placing the three sources of authoritarian constitutionalism of the continental European of the continental constitutional tradition at the same level: divine constitutionalism, Jacobin constitutionalism, and finally the external power which occupies the others and gives the constitution. It is interesting. I think that these sources of authoritarianism explain mainly the less pre-war continentalism and the past to which European Union constitutionalism is explaining the consensual Brexit that occurred as opposed to this authoritative constitution making. However, and this is my question, my point, I think that although you place them at the same level for analytical purposes, which is very useful and, as I say, original, I think that the tone is set by your question at page whatever, where you say, I'm putting, yes, I need to put it down and then try to find it out. And it is where you question, if it is allowable to suspend basic freedoms and democratic procedures to save democracy and rule of law, why should this be banned for the aviation? I think that this is the essence of Jacobinism. And Jacobinism, in the sense of Schmittian Jacobinism, where he says in the crisis of parliamentary democracy, that parliamentarism is really in a position of total inability, faced with a minority which says that I know what is good for the people. And I think that this is really the creme de la creme of authoritarianism, which actually puts the other forces, including the divine power, and the external threat, because it uses, it becomes
Thank you. I also enjoyed the text a lot, and hopefully I was really. I also had in mind here Schmidt and the crisis of parliamentary democracy, and particularly page 6 when you are recounting what Rousseau thought about the dictatorship, so to say, of the majority. And this is also a point made by Schmidt. This, so, you call it democracy, particularly because of the representative factor that doesn't mean that there's no dictatorship also happening. That's revealed. And another point,
Because there are no rights, you mean?
Sorry?
No rights, no theory of rights. I mean, dictatorship present as well.
Yes, of course, if the majority uses its power to crush the minority,
because
even if they fulfill the representative democracy procedures to do so, you can be called a democracy. Unfortunately, would say, well, yeah, you can call it a democracy, but in fact, it's a dictatorship. Depending on the elements we subscribe to the idea of dictatorship. And yeah, another comment that maybe a side issue, and you emphasize outward-oriented democracy with regards to thinking and governing.
It's more or less taken from that.
But so here's what I'm trying to grasp the argument. And I find it very telling that it may just be that output trumps input. Certain situations. This means that, as you say in several parts, you can be, this is not necessary course of action, but it can be that use the authoritarian regimes the way to democratic ones. So you have the input, which is not democratic, I say, but the output might just be. And is this, might get a bit distorting this idea, because my last point would be, if this is the case, the question is always, what happens, or can there be output the right one?
No.
And if you don't have the input either, if you, so to say, if the authoritarian regime does not lead to the democratic step, it may as well be a contingent issue. Sort of in this, really, it may just be that we are sacrificing the input, without knowing whether the output will be satisfactory. I guess this is the whole dilemma of the paper, and if you have empirical examples where it has been the case, and we have observed empirical examples where it hasn't been the case. So this is
Yep.
ask you.
That's just what I mentioned. You cannot know in advance if someone who usurps power during such a revolutionary process or a constitution-making process uses it in a benevolent way and refrains from power after the constitution is established, and then we have a wonderful democracy and everything works fine, or whether or not he sticks to power and establishes a dictatorship or a new authoritarian regime. We saw that in Egypt, for instance. When there was the coup d'etat by the military, certain commentators in the West argued, well, let's wait and see, maybe the transformation to more democratic and rule of law structures, maybe the military is now the actor who can save the revolution. That was this hope for a sort of benevolent usurper of the revolution. And as we learned from Tillman's paper, they are not. But you can't, in that moment, you cannot know. But in that moment, it might also be, of the argument, might still be helpful to prevent even worse injustices. So if you have a society in a revolutionary situation, which is about to slide into civil war because of society, try to hijack the constitution-making process and try to gain access to the monopoly of force, military forces and police forces. And if various fractions succeed in doing this partially, and you are about to enter a civil war just because of this revolutionary situation, some sort of that usurpation of power might be helpful to prevent civil war. And that sounds harsh, but I think we see this in Iraq, for instance. Sometimes an authoritarian regime is better than a failed state and civil war. So. I'd like to also say something about this Jacobinism argument. Of course, this is a huge problem. And that's also why I would like to formulate democratic constitution making and authoritative constitution making as ideal types. This is in my conclusion, which in historical empirical examples never occur or rarely occur in their pure form. So in real life processes, you have certain mixtures of democratic elements and authoritative elements. And as I argue, it's often a wise and often a lucky mixture of contingent factors which come into play, which decide about the success of a constitution-making process. And my argument, an empirical argument or an empirical hypothesis, that in constitution-making process, authoritative means prevail or have an important impact or role, that might contribute to the success of the democratic constitution-making process.
If there's no one else, I might have two questions or comments. Well, the first one is about the process, and I'm wondering, in this authoritative constitution making, would you have any preferences or any comments regarding the process? Should we prefer a clear break with the past and start anew from scratch, or to use the existing rules? I have two examples in mind. We had the Hungarian constitution was actually constituted through a series of amendments of the older constitution, like was in Chile in the early 90s. The old constitution was passed from authoritative one to a democratic one by using amendments to the old constitution. But the problem with that is that on the one hand it was good because it has this element of legality and legal legitimacy, but on the other hand, it caused this element of continuity that actually hindered the process of democratization. And we see what's happening now in Hungary. And it is only my own take that this is part of the the original sin using the original constitution. So I just wonder. I mean, you can say this is contrasting opinions of Andrew Arato and Bruce Ackerman. Ackerman says, yeah, you need a clear break. Now it says, no, you can use the old rules. And I just wonder, what is your take on that? Second, because I'm interested in the theory of constituent power, and I just wonder, in this theory that you bring, what does it say as for who is the bearer of constituent power? I mean, you mentioned at the beginning, Buchenwald. I only use things that were translated. He has this collection going to be published in English in the next few months. But for him, constitution making is a purely democratic process, right? It's a pouvoir constitutionnel. It belongs to the realm of democracy. But what you portray goes against it. So I just wonder, perhaps we need to, I think what Carl Schmitt is pointing to, the distinction between initiation of constituent power and exercising constituent power. So the initiation, like we see in Egypt, or when you have thousands of people in the square, the revival of the people, that's the initiation of constituent power that really comes from the people. But the exercise of constituent power must always be already a constituted process that requires some form of representation.
What constitutes it?
Exactly, but this is the paradox. So there's an internal link between constituent and constituent powers always. And in that respect, this is, again, for the theory of constituent power, you mentioned the external influences to this recent debate between Hans Agne and Mark Tushnet and Icon. So Agne has said, we the people and others, about how the external influence in constitution making is actually democratic. And Tushnet replies, so I think you should check it out.
First question about this, whether or not one has to make a clear break, depends on the situation. If there's a constitutional tradition in a country with, like we have in the countries of the Arab Spring, which all had some sort of constitution, but which was not really applied, or, well, they were written down, but those guys in power, they found ways to manipulate constitutional reality to their advantage, and so on. So if you have countries with that sort of constitutional tradition, and if those documents somehow serve as a starting point, I think they can be used as such. I mean, when we take a look at Germany, the drafting of the Weimar Constitution, when Hugo Preuss wrote it, he started from the 1848 Constitution, which was never put into place, but which was drafted in 1848, and he made changes to that constitution. So I think.
But even though these constitutions enhance governmental power rather than restricted it, so this was famous, constitutions in the world. Just a point to think about.
So and so then the second question, of course, the constituent power in this theoretical framework I'm developing here still lies at the people. So as you said, one has to distinguish between, as you call it, the initiation of constituent power and the exercise. And that's why I cite Hannah Arendt there, and where she spoke, or when she cited Aristotle herself, that that a society can commission the legislature. So it's an act of the demos, which in a certain situation, in a revolutionary situation, has the political will to reconstitutionalize its polity, give it a new structure, following certain norms. But in this self-commitment realizes that oh, if I'm left alone now, me, the demos, yeah, capable to give myself these rules. Yeah, there are cleavages, there are fractions, and so on and so on. I don't have, well, my society is not in a state where it can draft such a constitution. So I have to find someone who helps me, from outside, preferably from outside, because all internal actors are suspicious, both in politics and so on. So yes, the demos remains the constituting power, but it commissions some external authoritative constitution maker.
Yeah. My mind, I wanted I very much think that the talk I recently had the second vice president of Afghanistan who came to Germany for some work with us, and we talked about the legitimacy of the process of changing the constitution and of the constitution itself, the product. And before was part of the discussion. So how can you legitimize the process and the outcome with these religious arguments and effectiveness, which is very important? Try to discuss discussions to draw a bit on experiences, not only the effect. You have this regulatory impact assessment as we were using Schiller in NADA, that's different from the Islamists in Egypt. In NADA, people that I met in 2011 were very pragmatic. Many of them had business backgrounds. They didn't want the economic breakdown. They were involved in tourism. So they said, okay, if we go too far, tourism will be dead. We have to protect it. Whereas the Islamists in Egypt, in these businesses, they're in jail most of the time. So they're different, much more radical paths they were seeking, following. External and internal expertise is a very interesting aspect as well, which shines up in your both folks. And it's interesting, in Egypt, for example, they were very convinced that there should not be any outside hints, whereas the Tunisians, which are generally, I would say, very high qualified constitutional lawyers, excellent professors there, were very much interested in that. And for example, they were seeking us as German constitutional lawyers to advise them on the system of the German Constitutional Court, because this is what they didn't know from France. Whereas the Egyptians kind of closed the doors. Fora that you can find and develop. We were involved in Yemen also at a certain point in this national dialogue. It was a fantastic idea, and the documentation that is existing, there's a big slide that went to parts of it, is highly interesting, fantastic ideas, but they were not able to control the country. In Egypt, they would have had a chance, and the forum was provided for a certain time by Al-Azhar University, which would have been a very legitimate partner or actor in the view of the people. Many people said, let Al-Azhar guide us through the process, and they were open to talk with cops and unionists and employers and so on. But this was not acceptable to the military. So it is a very interesting thing, and as you said, it's very individual. It's very situational and kind of connected to the culture. In Afghanistan, very clearly, you have to involve this institutional process. Now, Ashraf Ghani had 2 years ago promised they will change the constitution. It shouldn't be done now. By now, it should have been changed. Why doesn't he do it? Karzai had this network in the whole country. Ashraf Ghani feels that he can't keep it under control, so it feels that the outcome would be something that he didn't want. It's just a little bit like jumping from one flower to the other, anecdotal, but countries that are in a situation like Afghanistan are a bit more lucky because they don't have to do it immediately. A country like Tunisia and Egypt had to act and react immediately. And I'm very much impressed as you seem to model. Maybe also because they had such an experience already. Already in the 19th century, 1861, they were the first to have kind of a rather modern human rights developed and were again kind of the avant-garde in the Arab world.
Yeah, I think I just an observation recommendation based on economics and other discussion about apparatus, internal constitution as learning process. So I think my observation of this paper is that there is a preference as expressed in as opposed to the democratic attempt to make a constitution, but end up with nothing. Then we an authoritative power or anything step in to impose or give a framework within which the continuing dialogue can continue. I think if my observation is correct, then I think that this has much to do. This can be linked in a very constructive way to the point Jan made of Andrew Arato constitution making law process. So I would suggest maybe the authoritative constitution making Andreas suggested in this paper may be restricted to a narrow framework constitution. On that very formal constitution, then I don't think yes, some framework would be better for nothing at all. But if this imposed constitution becomes comprehensive, then it itself becomes a problem.
Yeah, we have 2 minutes.
Yeah, I know the best practice in constitution
Can you speak up?
Say, as a lawyer,
Just speak louder.
as a lawyer, it's probably really that I would say it's great if there is a democratic movement, which kind of says now we want to change, and then, however, we don't have we pass it on to experts, ideally legal experts, and the experts know the rule of law, who actually subscribe to and then we make a constitution which limits democratic movement in combines it with my answer to that as a lawyer. However, I think that's why I find this the title constitutional making, ideal constitutional making in a non-ideal world. What I find that we might expect a certain outcome. So we actually quit, we kind of stop, and we say, okay, it's great, you are becoming a lawmaker and people on the street, but now you have to have a certain outcome, you have to have a constitution which accepts the human rights. And in a sense of the way we, the Western world, understand human rights in a very individualistic way. And I, that the example is great, but you can go to any other country, especially post-colonial mindsets, and especially countries in Africa or even in Asia. My favorite example is Indonesia, for example. I think the biggest Muslim country in the world, and they have a constitution, which is a modern constitution, it's a democratic constitution, accepts formally human rights, but they have a big problem with exception. It's because, as well, their community is a community building mindset, like in African communities. So for them, individual rights are decisive for them. Actually, of course, it's the community who decides what I am supposed to be individual. But that putting aside, the thing is, I have the impression that our best practice approach to this constitution with experts or we expect that there will be an outcome of the constitution with human rights, individual rights, and the rule of law, because we think this is not only the best practice of constitutionalism, but the best practice of constitution. And when I look at the process of our Western constitution making 200 years, I mean, French Revolution was one of the truest revolutions, actually to outbreak of human rights, but the most true revolution. And it was a process. The German constitution now is made even the best practice process that days. It was a strong false error process. So that's why I'm not trying to, I'm not saying it's because I just don't know. But I'm very interested with the experts, but whatever, what is the best that I really want to add? There is this really dangerous, you said, it should be, people need to do it themselves. Whatever comes out.
Well, a lot of food for thought, and from food to thought, we'll move to food body. So please allow me to thank Andreas and Amnon for this second part of the panel. Or break, we're going to go for lunch at a place called Aroma. It's a coffee shop. It's on the 6th floor. You do not need to pay for the lunch. It will be provided, and they've reserved a small room for us. So bon appetit, and I'll see you here in 1 hour precisely. We reconvene at 2 o'clock.